The International Military Tribunal for the Far East, also known as the Tokyo Trials, the Tokyo War Crimes Tribunal, or simply the Tribunal, was convened on April 29, 1946, to try the leaders of the Empire of Japan for three types of war crimes. Class A crimes were reserved for those who participated in a joint conspiracy to start and wage war, and were brought against those in the highest decision-making bodies. Class B crimes were reserved for those who committed conventional atrocities or crimes against humanity. Class C crimes were reserved for those in the planning, ordering, authorization, or failure to prevent such transgressions at higher levels in the command structure. 28 Japanese military and political leaders were charged with waging aggressive war and with responsibility for conventional war crimes. More than 5,700 lower-ranking personnel were charged with conventional war crimes in separate trials convened by Australia, China, France, the Netherlands, the Philippines, the United Kingdom and the United States. The charges covered a wide range of crimes including prisoner abuse, rape, sexual slavery, torture, ill-treatment of laborers, execution without trial and inhumane medical experiments. China held 13 tribunals, resulting in 504 convictions and 149 executions. The Japanese Emperor Hirohito and all members of the imperial family, such as career officer Prince Yasuhiko Osaka, were not prosecuted for involvement in any of the three categories of crimes. Herbert Bix explained. The Truman administration and General MacArthur both believed the occupation reforms would be implemented smoothly if they used Hirohito to legitimize their changes. As many as 50 suspects, such as Nobusuke Kishi, who later became prime minister, and Yoshisuke Aikawa, head of Nissan, were charged but released in 1947 and 1948. Shiro Ishii received immunity in exchange for data gathered from his experiments on live prisoners. The lone dissenting judge to exonerate all indictees was Indian jurist Radha Binod Pal. The tribunal was adjourned on November 12, 1948. Background: the tribunal was established to implement the Cairo Declaration, the Potsdam Declaration, the Instrument of Surrender, and the Moscow Conference. The Potsdam Declaration had called for trials and purges of those who had deceived and misled the Japanese people into war. However, there was major disagreement, both among the Allies and within their administrations, about whom to try and how to try them. Despite the lack of consensus, General Douglas MacArthur, the supreme commander of the Allied powers, decided to initiate arrests. On September 11, a week after the surrender, he ordered the arrest of 39 suspects, most of them members of General Hideki Tojo's war cabinet. Tojo tried to commit suicide, but was resuscitated with the help of U.S. doctors. Creation of the court. On January 19, 1946, MacArthur issued a special proclamation ordering the establishment of an international military tribunal for the Far East. On the same day, he also approved the Charter of the International Military Tribunal for the Far East, which prescribed how it was to be formed, the crimes that it was to consider, and how the tribunal was to function. The charter generally followed the model set by the Nuremberg trials. On April 25, in accordance with the provisions of Article 7 of the CIMTFE, the original rules of procedure of the International Military Tribunal for the Far East with amendments were promulgated. Judges MacArthur appointed a panel of 12 judges, 9 from the nations that signed the Instrument of Surrender. The famous legal scholar Roscoe Pound was also apparently favorably disposed to replacing John P. Higgins as a judge, but an appointment did not eventuate. Prosecutors: the chief prosecutor, Joseph B. Keenan of the United States, was appointed by President Harry S. Truman. Defendants: 28 defendants were charged, mostly military officers and government officials. Civilian officials: Koki Hirota, Prime Minister, Foreign Minister, Kiichiro Hiranuma, Prime Minister, President of the Privy Council; Naoki Hoshino, Chief Cabinet Secretary; Koichi Kido, Lord Keeper of the Privy Seal; Toshio Shiratori, Ambassador to Italy; Shigenori Togo, Foreign Minister; Mamoru Shigemitsu, Foreign Minister; Okinori Keiya, Finance Minister; Yusuke Matsuoka, Foreign Minister; Military Officers General Hideki Tojo, Prime Minister, War Minister, Chief of the Imperial Japanese Army General Staff Office; General Seishiro Itagaki, War Minister; General Sadao Araki, War Minister; Field Marshal Shunroku Hata, War Minister; Admiral Shigetaro Shimada, Navy Minister, Chief of the Imperial Japanese Navy General Staff; Lieutenant General Kenrya Sato, Chief of the Military Affairs Bureau; General Kuniaki Koisa, Prime Minister, Governor-General of Korea; Vice Admiral Takazumi Oka, Chief of the Bureau of Naval Affairs; Lieutenant General Hiroshi Oshima, Ambassador to Germany; Fleet Admiral Nagano Osami, Navy Minister, Chief of the Imperial Japanese Navy General Staff; General Jiro Minami, Governor-General of Korea; General Kenji Doihara, Chief of the Intelligence Service in Manchukuo; General Haitaro Kimura, Commander of the Burma Area Army; General Iwan Matsui, Commander of the Shanghai Expeditionary Force and Central China Area Army; Lieutenant General Akira Muto, Chief of Staff of the 14th Area Army; Colonel Kingoro Hashimoto, founder of Sakurakai; General Yoshijiro Umezu, Commander of the Kwantung Army, Chief of the Imperial Japanese Army General Staff Office; Lieutenant General Taichi Suzuki, Chief of the Cabinet Planning Board. Other defendants: Shumai Okawa, a political philosopher. Tokyo War Crimes Trial. Following months of preparation, the IMTFE convened on April 29, 1946. The trials were held in the War Ministry office in Tokyo. On May 3, the prosecution opened its case, charging the defendants with conventional war crimes, crimes against peace, and crimes against humanity. The trial continued for more than 2.5 years, hearing testimony from 419 witnesses and admitting 4,336 exhibits of evidence, including depositions and affidavits from 779 other individuals. Charges following the model used at the Nuremberg trials in Germany, the Allies established 3 broad categories. Class A charges, alleging crimes against peace, were to be brought against Japan's top leaders who had planned and directed the war. Class B and C charges, which could be leveled at Japanese of any rank, covered conventional war crimes and crimes against humanity, respectively. Unlike the Nuremberg trials, the charge of crimes against peace was a prerequisite to prosecution. Only those individuals whose crimes included crimes against peace could be prosecuted by the tribunal. The indictment accused the defendants of promoting a scheme of conquest that contemplated and carried out murdering, maiming and ill-treating prisoners of war civilian internees, forcing them to labor under inhumane conditions, plundering public and private property, wantonly destroying cities, towns and villages beyond any justification of military necessity, mass murder, rape, pillage, brigandage, torture and other barbaric cruelties upon the helpless civilian population of the overrun countries. Keenan issued a press statement along with the indictment. War and treaty breakers should be stripped of the glamour of national heroes and exposed as what they really are, plain, ordinary murderers. It submitted its evidence in 15 phases. The charter provided that evidence against the accused could include any document, without proof of its issuance or signature, as well as diaries, letters, press reports, and sworn or unsworn out-of-court statements relating to the charges. Article 13 of the Charter read, in part, the tribunal shall not be bound by technical rules of evidence, and shall admit any evidence which it deems to have probative value. Wartime press releases of the Allies were admitted as evidence by the prosecution, while those sought to be entered by the defense were excluded. The recollection of a conversation with a long-dead man was admitted. Letters allegedly written by Japanese citizens were admitted with no proof of authenticity and no opportunity for cross-examination by the defense. The tribunal embraced the best evidence rule once the prosecution had rested. The best evidence rule dictates that the best, or most authentic evidence must be produced. Justice Powell, one of two justices to vote for acquittal on all counts, observed, "In a proceeding where we had to allow the prosecution to bring in any amount of hearsay evidence, it was somewhat misplaced caution to introduce this best evidence rule, particularly when it operated practically against the defense only." To prove their case, the prosecution team relied on the doctrine of command responsibility. This doctrine was that it did not require proof of criminal orders. The prosecution had to prove three things: that war crimes were systematic or widespread, the accused knew that troops were committing atrocities, and the accused had power or authority to stop the crimes. The prosecution argued that a 1927 document known as the Tanaka Memorial showed that a common plan or conspiracy to commit crimes against peace bound the accused together. Thus, the prosecution argued that the conspiracy had begun in 1927 and continued through to the end of the war in 1945. The Tanaka Memorial is now considered by most historians to have been a forgery. However, it was not regarded as such at the time. The defendants were represented by over 100 attorneys, 3/4 of them Japanese and 1/4 American, plus a support staff. The defense opened its case on January 27, 1947, and finished its presentation 225 days later on September 9, 1947. The defense argued that the trial could never be free from substantial doubt as to its legality, fairness and impartiality. The defense challenged the indictment, arguing that crimes against peace, and more specifically, the undefined concepts of conspiracy and aggressive war, had yet to be established as crimes in international law. In effect, the IMTFE was contradicting accepted legal procedure by trying the defendants retroactively for violating laws which had not existed when the alleged crimes had been committed. The defense insisted that there was no basis in international law for holding individuals responsible for acts of state, as the Tokyo trial proposed to do. The defense attacked the notion of negative criminality, by which the defendants were to be tried for failing to prevent breaches of law and war crimes by others, as likewise having no basis in international law. The defense argued that Allied powers' violations of international law should be examined. Former Foreign Minister Shigenori Togo maintained that Japan had had no choice but to enter the war for self-defense purposes. He asserted that because of the whole note, we felt at the time that Japan was being driven either to war or suicide. Judgment. The IMT spent 6 months reaching judgment and drafting its 1,781-page opinion. On the day the judgment was read, 5 of the 11 justices released separate opinions outside the court. In his concurring opinion, Justice William Webb of Australia took issue with Emperor Hirohito's legal status, writing, "The suggestion that the emperor was bound to act on advice is contrary to the evidence." While refraining from personal indictment of Hirohito, Webb indicated that Hirohito bore responsibility as a constitutional monarch who accepted ministerial and other advice for war, and that no ruler can commit the crime of launching aggressive war and then validly claim to be excused for doing so because his life would otherwise have been in danger. It will remain that the men who advise the commission of a crime, if it be one, are in no worse position than the man who directs the crime be committed. Justice Delfin Jaranilla of the Philippines disagreed with the penalties imposed by the tribunal as being too lenient, not exemplary and deterrent. and not commensurate with the gravity of the offense or offenses committed. Justice Henry Bernard of France argued that the tribunal's course of action was flawed due to Hirohito's absence and the lack of sufficient deliberation by the judges. He concluded that Japan's declaration of war had a principal author who escaped all prosecution and of whom in any case the present defendants could only be considered as accomplices, and that a verdict reached by a tribunal after a defective procedure cannot be a valid one. It is well nigh impossible to define the concept of initiating or waging a war of aggression both accurately and comprehensively, wrote Justice Rolling of the Netherlands in his dissent. He stated, "I think that not only should there have been neutrals in the court, but there should have been Japanese also." He argued that they would always have been a minority and therefore would not have been able to sway the balance of the trial. However, they could have convincingly argued issues of government policy which were unfamiliar to the Allied justices, pointing out the difficulties and limitations in holding individuals responsible for an act of state and making omission of responsibility a crime. Rolling called for the acquittal of several defendants, including Hirota. Justice Radha Binod Pal of India produced a 1,235-page judgment in which he dismissed the legitimacy of the IMTFE as victor's justice. "I would hold that each and every one of the accused must be found not guilty of each and every one of the charges in the indictment and should be acquitted on all those charges, while taking into account the influence of wartime propaganda, exaggerations, and distortions of facts in the evidence, and overzealous and hostile witnesses." Pal concluded, "The evidence is still overwhelming that atrocities were perpetrated by the members of the Japanese armed forces against the civilian population of some of the territories occupied by them as also against the prisoners of war." Sentencing one defendant, Shumei Okawa, was found mentally unfit for trial and the charges were dropped. Two defendants, Matsuoka Yusuke and Nagano Osami, died of natural causes during the trial. 6 defendants were sentenced to death by hanging for war crimes, crimes against humanity, and crimes against peace. General Kenji Doihara, chief of the intelligence services in Manchukuo; Koki Hirota, prime minister; General Seishiro Itagaki, war minister; General Haitaro Kimura, commander, Burma Area Army; Lieutenant General Akira Muto, Chief of Staff, 14th Area Army; General Hideki Tojo, Commander, Kwantung Army. One defendant was sentenced to death by hanging for war crimes and crimes against humanity. General Iwan Matsui, Commander, Shanghai Expeditionary Force and Central China Area Army. They were executed at Shugama Prison in Ikebukuro on December 23, 1948. MacArthur, afraid of embarrassing and antagonizing the Japanese people, defied the wishes of President Truman and barred photography of any kind, instead bringing in 4 members of the Allied Council to act as official witnesses. 16 defendants were sentenced to life imprisonment. 3 died in prison, while the other 13 were paroled between 1954 and 1956. General Sadao Araki, war minister; Colonel Kingoro Hashimoto, major instigator of the Second Sino-Japanese War; Field Marshal Shunroku Hata, war minister; Baron Kiichiro Hiranuma, prime minister; Naoki Hoshino, chief cabinet secretary; Okinori Keiya, finance minister; Marquis Koichi Kido, Lord Keeper of the Privy Seal; General Kuniaki Koisa, governor of Korea, later prime minister; General Jiro Minami, commander, Kwantung Army; Admiral Takazumi Oka, naval minister; Lieutenant General Hiroshi Oshima, ambassador to Germany; General Kenrya Sato, chief of the Military Affairs Bureau; Admiral Shigetaro Shimada, naval minister; Toshio Shiratori, ambassador to Italy; Lieutenant General Taichi Suzuki, president of the Cabinet Planning Board; General Yoshijiro Umezu, war minister; Foreign Minister Shigenori Togo was sentenced to 20 years imprisonment and died in prison in 1949. Foreign Minister Mamoru Shigemitsu was sentenced to 7 years. The verdict and sentences of the tribunal were confirmed by MacArthur on November 24, 1948, 2 days after a perfunctory meeting with members of the Allied Control Commission for Japan, who acted as the local representatives of the nations of the Far Eastern Commission. 6 of those representatives made no recommendations for clemency. Australia, Canada, India, and the Netherlands were willing to see the general make some reductions in sentences. He chose not to do so. The issue of clemency was thereafter to disturb Japanese relations with the Allied powers until the late 1950s, when a majority of the Allied powers agreed to release the last of the convicted major war criminals from captivity. Other war crimes trials. According to Japanese records, 5,700 Japanese individuals were indicted for Class B and Class C war crimes. Of this number, 984 were initially condemned to death, 475 received life sentences, 2,944 were given more limited prison terms, 1,018 were acquitted, and 279 were never brought to trial or not sentenced. The number of death sentences by country is as follows: the Netherlands 236, Great Britain 223, Australia 153, China 149, United States 140, France 26, and Philippines 17. The Soviet Union and Chinese Communist forces also held trials for Japanese war criminals. The Khabarovsk war crime trials held by the Soviets tried and found guilty some members of Japan's Bacteriological and Chemical Warfare Unit, also known as Unit 731. However, those who surrendered to the Americans were never brought to trial. As Supreme Commander of the Allied powers, MacArthur gave immunity to Shiro Ishii and all members of the bacteriological research units in exchange for germ warfare data based on human experimentation. On May 6, 1947, he wrote to Washington that additional data, possibly some statements from Ishii, probably can be obtained by informing Japanese involved. That information will be retained in intelligence channels and will not be employed as war crimes evidence. The deal was concluded in 1948. In 1981, John W. Powell published an article in the Bulletin of the Atomic Scientists detailing the experiments of Unit 731 and its open-air tests of germ warfare on civilians. It was printed with a statement by Judge Rowling, the last surviving member of the Tokyo Tribunal, who wrote, as one of the judges in the International Military Tribunal, it is a bitter experience for me to be informed now that centrally ordered Japanese war criminality of the most disgusting kind was kept secret from the court by the U.S. government.